Let's dive into things. So the session today is on trademarks and intellectual property, and we're just going to be going through some of the legal basics for startups and small businesses that are interested in making sure they've protected their trademarks and learning about the basics of intellectual property protection. So I'm going to be running through a bunch of different concepts and relations in relation to intellectual property and spending a bit more time on trademarks as well in terms of how you can register and protect the trademarks for your business. Before we dive into things, just wanted to give you a little bit of introduction to Sprintlaw for those of you that are not current clients or members. So Sprintlaw is an online law firm for small businesses and startups. We've been around since about early 2017. I'm one of the two co-founders of the business. Like many of our smaller startup clients, we started off as a sort of two co-founder working from an apartment operation. Raised multiple rounds of capital and have grown to a fairly large team. So been through that journey, in setting up and building a business, and we sort of love helping our clients who are sort of going through similar things as well. The way our business works is quite different to your traditional law firms. We do fixed fee legal services. So all of our services are not charged by the hour, but rather we give you a quote up front, and that's the price for our service. We have an optional membership. About 85% of our clients sign up to it. It's a really great way for you to sort of get ongoing legal support from our legal team. As a Sprintlaw member, you get access to unlimited quick calls with our lawyers, discounts on our services, and some other software tools. And we're actually in the process of revamping our membership, adding in a lot of the new GPT, NLP stuff that a lot of people are talking about, and working out how we can apply that to small business legal services. So there's some of those sorts of benefits for Sprintlaw members as well. We are Australia and in fact Asia Pacific's fastest growing legal business, as named by the Financial Times, something I'm quite proud of. We have a bit over 4,000 clients, lots of positive reviews, and we're a team of 50, and we've won tons of industry awards. So if we're not your lawyers already, definitely consider it. And I guess our main point of difference to traditional law firms is, first of all, we've got a big team of specialist lawyers in basically every area of business law, from intellectual property to leasing to commercial contracts, capital raising. We have different lawyers for all those different areas. Because we've helped so many small business and startup clients, we have a lot of data on what's normal in terms of what clauses should go in your documents, what are the interest you should charge on payments and those sorts of things, and we feed that into the advice that we give. And I suppose most of all, we're really easy to use and very affordable, and really trying to make this law thing a lot more accessible for smaller organizations. We're also running a promotion at the moment. If after this presentation you decide that you need to register some trademarks or get some advice around trademarks, which you may do, we have, I think for all of April, some additional discounts on our normal trademark packages. So registering, renewing, just getting advice, or if you want to expand internationally with your trademarks, advice around that as well. So if you're interested after this webinar, feel free to reach out to our team and mention the offer, and we can explain the details. So now just into the legal side of things, I'm going to be covering 4 or 3.5 areas of intellectual property law in this presentation. First, I'll be talking about trademarks. I'll be talking about copyright. I'll be talking about confidential information. That's the 0.5. It's kind of intellectual property, and it's useful to think of in this lens, and I'll explain that in a bit more detail later. And then we have patents. Now, patents and designs I've marked orange. I won't be talking too much about patents and designs, mainly because they're not super applicable, at least in the case of patents, to smaller organizations, unless you're running a sort of high-tech business or something in the medical or pharmaceutical space. I'll give you a quick overview of what they are now, and if people have questions about them, feel free to drop them in the chat, and happy to, if we have time at the end, answer a few questions about patents. But patents are a type of registration for highly inventive forms of intellectual property. If you invent a new device, a really complex software, or some sort of scientific formula, or pharmaceutical product, you may be able to register a patent for it, and it gives you a very high degree of sort of monopoly ownership of that invention, but typically doesn't come up in businesses that aren't oriented towards patents. And designs, which I'll touch on briefly, are similar to trademarks, but they're for products. So you can register protections for things like furniture or furniture designs or other product designs and product shapes and things like that. Again, won't spend too much time on it, but if people have questions, happy to answer them. But yeah, the focus of this presentation is really on trademarks, copyright, confidential information. So just kicking off with trademarks. What is a trademark? Well, a trademark is a registration that you can get to protect your brand. And there's sort of two main types of trademarks that pretty much every business wants to consider. One is a trademark for your business name, and the second is a trademark for your logo or tagline or other associated sort of brand identity. You can also register trademarks for other things like shapes, colors, scents, and those sorts of things. But most trademarks that we do for small organizations are these two, the business name and the logo. And to explain that in a bit more detail, Sprintlaw, for example, has registered a trademark for the word Sprintlaw and also for our logo. So this little S-shaped design that we have. And if your organization has a business name, which most of you probably will, and a logo of some description that's looks a bit different to just the business name in typography, those would be the two basic trademarks you'd want to think about registering. So why do you register a trademark? Well, when you register a trademark, it gives you the exclusive right to use that word or that logo in your class or industry and in the country that you've registered. So again, using the example of Sprintlaw, because we own the word trademark for Sprintlaw and for this little S thing in class 45, which is the legal industry, that means no one else in the legal industry can promote products or services using the word Sprintlaw, or promote products or services using this sort of S shape. And that's significant because we're investing a lot of sort of time and money and effort in building our brand and growing our brand. We want to make sure that we own it, that someone else can't come along and sort of do something similar and trade off our goodwill. Now, the registration doesn't just protect the exact replica of the word Sprintlaw. If someone wanted to register a trademark for something or start using a business or product name Sprint Legal or Sprint Lawyers, trademarks still protect anything that is similar to the overall impression of what you have registered. And similarly, if somebody started another legal business that used this S shape, but it might be called something completely different, Simple Law, but they've used this S thing, again, they may be infringing our mark because they may be confusing customers and essentially trading off our goodwill. So that's the advantage of the trademark registration. When you register, if you get it through successfully, you've got 10 years exclusive right to use that. And you can license the right to use that if you have a product name or some sort of service that you've created or methodology you've created that you want to protect the name of. You can license the right to use that. You can sell it to people. It becomes a piece of property, and you've got the exclusive right for 10 years. And you can renew it every 10 years indefinitely. And provided that you're continuing to use it, it's relatively straightforward to get those renewals. So trademarks are really the primary way the legal system allows you to get ownership over your brand. So if you're thinking, should I register a trademark, or if you haven't already, have I appropriately trademarked all my stuff? I would say there's sort of three questions you want to think about. First of all, what is your brand and what do you need to protect? Second of all, checking that you actually own your brand. And third of all, if you do own it, how are you actually using this thing and making sure that others aren't using it now that you have that ownership right? So I'll just go through each of these in a little bit of detail, starting with identification. So for your business, you should be thinking, what are my key trademarks? As I mentioned earlier, there's really these sort of three common things that you want to be thinking about. Your business name, or if there's a product that you have, a product name. If there's a word that is critical to your business, in our case, it's obviously Sprintlaw. Can you register a trademark for that? Second is a logo. Do you have a logo that's different to the word? So in our case, we have this S stamp. Do you have some sort of brand stamp or insignia or something that is closely associated with your brand? If so, you might want to protect that too. And third of all, and I think we've just had a question for Betsy come through on this. Can slogans be trademarked? Yes. So catchphrases, slogans. Ours is business legals made simple. Things like that can be trademarked as well. So all three of those things are trademarkable. As I mentioned earlier, things like shapes, the shape of the Coca-Cola bottle, famously is trademarked. Colors are trademarked, can be trademarked. Cadbury's purple's trademarked. I think ANZ's blue is trademarked. In some cases, it's very difficult to get them. Scents can be trademarked. So there are a few different types of brand-associated things that can be trademarked, but really these are the most common ones that smaller organizations are sort of securing. And I think I mentioned earlier, when you trademark something, we're protecting the overall impression of the trademarks, which is why things like Sprint Lawyers, Sprint Legal, or even an S that doesn't quite look like this S but is relatively similar, all those things can be protected once you secure a registration. So how do you actually get this registration? Well, in Australia, the process is not super quick. It actually takes around 7.5 months. And what you do is you submit an application with IP Australia, and I'll run through a high level of the process in a moment, but you submit an application with IP Australia. IP Australia is going to consider, does this thing that you want to register, your name, your logo, whatever it is, catchphrase, does it meet the requirements for registrability? So first of all, there needs to be some distinctiveness element. You can't trademark, chair, and then say no one else can use the word chair. Although you may be able to register something like chair, because you register on an industry basis, you might be able to register something like chair in an unusual industry. So you might not be able to register it in the furniture industry, but you might be able to register chair in the legal industry. If someone wanted to create a law firm called Chair, it's a relatively unusual use of the term chair, so it may be possible to get a trademark for chair in the legal industry, but certainly not in furnitures. Quite famously, Apple have a trademark for apple. Now, obviously, in sort of in the fruit industry or the fruit and vegetable industry, having a registration for apple and then trying to prevent anyone else from selling apples or describing their products as apples wouldn't be possible. But under the trademark laws, in the computer space or the information technology space, having a registration for Apple can become distinctive enough to allow your trademark to go through. So it's not a given when you apply that you're going to get it. There's laws, there's things that need to be considered around distinctiveness. The second thing that will be considered is, does someone else already have this or something similar to this? So, if you wanted to register a trademark for, Sprint Legal, you might try, but then, the IP Australia might say, well, look, that's too similar to these people's Sprintlaw, so we're not going to approve your application. So it's not a given. It takes time. There is a process IP Australia introduced a few years ago called Head Start, which at least gives you a sense very quickly whether you're likely to be approved or not. So you're not waiting 7.5 months to even know if you're going to get your trademark. But yeah, it does take time. So that's worth thinking about. Now, the registration that we're talking about so far is an Australian registration. If your organization has plans to expand internationally, you might want to get trademarks in other jurisdictions. Certainly something with our scale-up startups that we see a lot. They have registered their Australian marks, but they end up expanding internationally, sometimes to countries that they hadn't really thought they might expand to when they first began the business. And they learn that someone else has the trademark already in that market, and they're either forced to rebrand or do a deal with whoever the trademark owner is, and it can be very damaging to the business and cause a lot of issues. So definitely worth thinking about securing your international trademarks from early on in your business journey, or well before you're planning an international expansion, just to make sure you've secured it. There's kind of two different ways you can get your international marks. One is to go direct, which means you find lawyers or trademark attorneys in in each country and chat to them and get them to register it for you. More commonly, we can, and most Australian lawyers can help you register using something called the Madrid Protocol, which is a international trademark treaty, and essentially allows you to sort of upgrade your Australian registration to domestic registrations in a bunch of different countries. I've got 130 countries signed up to it, so it's often the simplest way to get an international trademark. But some countries like China are not on there, so you may need to go direct in some cases. One other important thing to clarify is trademarks are not the same as registering a business name, which many of you may have done with ASIC, and registering a domain name, which a lot of people try and secure early on. Those two things are also important for brand ownership, but they in and of themselves do not give you the right to exclusively use a particular domain name or business name. If somebody purchased a domain called 2025 macbook.com, Apple has a trademark for MacBook, so while they may have been able to secure the domain name, Apple may say you're infringing our trademark, and they can actually demand a transfer back of a domain name. So a domain name is important. It can be a headache if someone else takes your domain name, so you definitely want to secure it, but it in and of itself does not give you the sort of exclusive right to use it, and you want to make sure you have both the trademark and the domain name. And similarly, the business name that you may register, the name of your company or the name of your business, that's like a legal requirement that you have to register a name and use that name on your contracts and documents and invoices, but there's no ownership rights that you get when you just make those basic ASIC registrations. Someone could make a product with the same name as your business. They never had to register it with ASIC, and they could register a trademark for that. And even though you've secured the business name, they could force you to stop using it because they have the trademark. So the trademark is really the strongest brand right. And I think a common misconception we see is people not quite realizing that it's different to the registrations you may have done when you first set up your business. And if I can just go on a sort of 1 minute public service announcement rant about trademarks specifically. In the past 6 years of doing Sprintlaw, I would say the failure to get the trademark registration done is by far the #1 biggest issue I've seen small businesses and startups encounter. It's really easy to do early on. If you speak to most lawyers, and I mean, for example, Sprintlaw did this as well. On the to-do list when you get set up at the beginning, I would say #1 is get your company set up, and #2 is get your trademark set up. Other things like your privacy policy and your documents, they can come a little later when you start taking on customers or setting up your website. But the trademark is really essential because it's your brand. It's what you're building your business around. It's what you're investing in. And if you don't own it, if someone else already has it that you don't know about, all of the time, effort, and money you spend in investing in this thing and building this thing, can go to waste because you have to rebrand, or can really slow your progression because you've got to fight someone for trademark rights. And this is a thing we very, very commonly see. Like I said, probably the most common legal issue. And there's two subsets of the common issue that we see. One is someone registers a trademark and then someone doesn't register a trademark, starts a business, and realizes later someone else already has the trademark and they're forced to rebrand. Another is the international issue. People expanding internationally find out that in their major international market, someone else has the trademark. And again, they're forced to sort of rebrand. And we've seen businesses fail because of this issue. They had to rebrand, lost their customers, and that was kind of it. So not to put too much fear into your hearts, definitely secure it early on if you can. So just to quickly step you through this process of a Head Start registration. This is the most common way in Australia to register a trademark. You submit an application with IP Australia. The reason it's called Head Start is in the standard trademark process, you often have to wait, all the way to the end of the period of application to find out whether you're going to get your trademark or not. And 7.5 months is a long time. And if you're going to need to rebrand, you want to get a sense as soon as possible. With the Head Start process, pretty quickly, within a few days, you get a report back from IP Australia telling you whether you're likely to be approved or denied. And if denied, they kind of give you the reasons for denial. And then you can proceed to a formal application. So if you decide to go ahead with a trademark registration, like I said, the process to get it fully locked in is that 7.5 months, but you'll kind of know whether you're successful or not fairly quickly. Issues do come up along the way just because they say likely doesn't mean there'll be no issues. It is, I'd say, uncommon, but not so uncommon as to be very rare that, you're 3 months in, you got a preliminary approval, but someone else, who already has a trademark sees that you have a trademark pending and sends a notice to oppose, it's called, and says, I don't want this person coming in with a trademark. It's too similar to mine, and issues can emerge along the way. If you have a relatively straightforward application, though, it will just fly through, and at the end of the 7.5 months, you'll get your registration. I've noticed there's a few questions in the chat, so I might just skim through and see if I can answer them while we're on the topic of trademarks. So Emil's asked the question, I have a soap making small business with unique shapes I'm hoping to protect. I believe that goes into the design category, and was hoping you can cover a bit of this during the session. I'll just briefly touch on the shapes concept. Shapes, there's two ways to protect shapes. One is as a shape trademark, and the second is as a registered design. The shape trademark is stronger but harder to get. Like I mentioned earlier, a shape trademark might go to something like the shape of the Coca-Cola bottle. And that means if someone else in that same industry, in the sort of food and beverage industry, or whatever the relevant class is, tries to use something shaped the same way as the Coke bottle, they may be infringing the shape trademark. But to get a shape trademark, you need something quite distinctive, because it's quite a strong right to protect the shape of something. It has to be an unusual shape, an innovative shape, and it has to pass the IP Australia tests of not being similar to other shapes and so on. It's more common if you have product designs or product shapes, so the shape of a chair, the shape of a sofa, or the shape of some other, or an overall design of a product that's more than just a shape, but it's a full sketch or blueprint of how this product is looked or laid out to get the design registration. So depending on what sort of shapes you want to protect for your soaps, it may be that you do a design registration or a shape trademark. Probably something to discuss with a lawyer, but those are the two options that you'd be considering. And if you can get the shape trademark, it's better because you get 10 years protection, whereas designs you only get 5. But the design one is a little bit easier to get. So hopefully that gives you a little bit of a sense as to how that works. Lee has asked, what happens if there's a breach? I'll be covering that in a couple of slides' time. And also a question around, if you perform a redesign of a logo without a major change, e.g. changing your shape slightly but keeping everything else the same, do you need to submit a new trademark request, or can the existing approved trademark be revised? So look, that's probably a question for a lawyer to look at what the change is and answer. As I mentioned, I think on one of the earlier slides, when you register a trademark, the overall impression of the trademark is protected. So we've got this S shape. If we added very slight adjustments to the S shape, changed the edges, added a little, I don't know, some sort of little design on top of it, but it was still clearly the S shape, and someone copied the slight variation. Again, if the overall impression is the same, and that's a very subjective test, which a lot of trademark law is, but if it's quite clear that if someone used that it looks exactly like the Sprintlaw S in the legal industry, it's going to be protected. So we may not need to register a separate logo mark for every different variation. That said, it is safer to, if we wanted to be extra careful, we could register for the variation, and big brands will register multiple versions of their trademarks every time they rebrand or change. Ultimately, whether you bother doing it is a question of how different is it, what's the risk of it being too far away from the original to not be captured by the original, and sort of how much budget do you have. So yeah, if you're interested in getting more advice on that, you can get our legal team to have a look and give you a sense as to whether it's worth the money, or if it's so similar it may not be worth the investment. But that's kind of how you think about those questions when you do a refresh or a rebrand. just quickly wanted to show people what it looks like when you register a trademark. This is from the IP Australia website, an extract of Sprintlaw's trademark registration. So you can see this is for our word mark, Sprintlaw. It's registered in class 45, which is a legal industry. You put a little description in. So within the legal industry is very broad, this legal class. So we've set all of the different types of things we want to use Sprintlaw for. It's got the owner, it's got the registration date, 18 Jan 2017, which is in fact, I think a week after Sprintlaw was founded. So I'm true to my word that it was the first thing that we did, and it will renew on 18 Jan 2027. So this is kind of what it looks like. And then if for the logo mark, we've registered this S shape as well. And again, class 45, it tells you that it's a different type of trademark. And we registered this a little bit later because we did our rebrand in, I think, 2020 and registered the mark at that time. So again, that gives you a little bit of a sense of how trademarks work in practice. So let's talk about trademark use and enforcement, which is one of the questions that came through. Okay, so you've registered a trademark. What now? What do you do with it? Well, I guess the first point is you can rest easy knowing that you own your brand, that you're, when you're building it up, you're genuinely building value in this asset that you own. If you ever want to sell the organization, there'll be value to the trademarks that you can sell. So there's a peace of mind element, of course, to registering, but then just to deal with a more cosmetic point, people would have seen the little TM or the little R things that people sometimes use together with their trademark. Completely optional as to whether you want to use them or not. You can only use the R shape if you have a successful, in Australia, if you have a successful registration that's gone through after that 7.5 or sometimes longer month period. If you use it when you don't have the R symbol, you're breaching the trademark laws. In the meantime, if you have a trademark pending, you can use the small TM symbol as well. You can use a small TM symbol either way, but there's not really any restrictions on using that symbol. But the R symbol is regulated, so that's just worth being aware of. And people choose to use it just as a stamp of credibility and to put people on notice that they own this word or phrase or whatever it is. So don't try and steal it. So that can help deter misuse of your trademark and also add credibility to your brand. Up to you whether you want to use it. We don't really use it very much at Sprintlaw, but a lot of our clients do. Now, what happens if someone is actually using your trademark? What if someone comes along, sets up a website, sprintlegal.com? They've got, a word that's very similar to Sprintlaw. They're hosting webinars. People are going to it thinking they're going to a Sprintlaw webinar, very clearly trading off our brand. Or even if it's a little more vague, maybe they're called law sprinters or something that's a little different, but still potentially the overall impression of it is misleading customers or potentially misleading customers that they may be related to Sprintlaw. So in these kinds of circumstances where you think you've got a case of somebody infringing your trademark, the most common first action is to try and resolve it with communication. You would typically start with a letter of demand, and you could say, you are currently infringing my trademark. You must cease and desist use. If you do not cease and desist use, further action will be taken. Please remove all references to my mark from XYZ place within X period of time. And a lot of the time, people are just not aware that you have a trademark, and they will, send an apology and cease to use it, or they'll make a commitment that they'll do a rebrand or whatever it is. So it's actually fairly common with the letter of demand to get the result that you might be after, which is to cease use. If they have profited off your trademark, you're aware of that, you may request some form of compensation for use. And again, you can do that in a letter, and you can discuss with a lawyer how much you want to ask and what calculation you want to use. But this is all a private resolution, which under the law, you're allowed to send these letters and you're allowed to request compensation if there is an infringement. But but the amount and the way in which you ask is sort of up to you and the strategy that you want to pursue. Underlying this, of course, is if they don't comply with your letter, if they ignore your letters, if they refuse to pay compensation, you have the right to commence litigation, file a claim against them. And the two types of claims you can file, one for damages and one for account of profits, and you can file for both at once. And you can basically say, I own this trademark. You've been doing X, Y, Z with my trademark. This has caused me this loss because you've damaged my brand, and I'm going to claim this amount of compensation. Or if it hasn't caused you loss, but instead they've profited, they've used your trademark to make sales or promote their products, you can say, that income, all of it or a portion of it should be mine because you used my goodwill and my trademark that I own to generate that revenue. And you can request what's called an account of profits. So these are often the underlying legal claims. Of course, in practice, people don't want to stand up in court and defend their trademark. So a lot of stuff is resolved over emails and letters, with references to the calculations. If we were to go to court, I would be able to claim this much from you. So therefore, I'm requesting this amount of compensation. So that's kind of how you use them in practice. You get the ownership rights, and you're then able to enforce them through letters and potentially legal claims. It's also, though, coming back to my first point, a peace of mind thing. While you've got your trademark registered, not only can you enforce it against people, you can also, be clear in knowing that you may not get a letter one day from someone else that owns a trademark and is accusing you of potential infringement because you've already secured your brand. So hopefully that gives people a good overview of trademarks. There is one other slide I had on unregistered trademarks. If you haven't yet registered your trademark and you find out that someone, you've been around for 5 years, you have a brand name, you find out that someone registered a year ago in your industry a trademark and you didn't know about it, and you feel that it should be yours because you're much bigger than them and you're more well-known than them, there are these things called unregistered trademarks where you can, in some cases, make a claim to say I had prior use of this trademark and their registration should never have been approved. It can be a difficult claim to make, but that is possible. So worth considering if you are unlucky enough to find out that you haven't got your trademark and someone else has got something that's preventing you from registering. The second is, even if you don't have a trademark registration, it is possible anyway to have rights in your brand name. If you've been around again for 10 years using a brand, promoting it, the law does recognize, even without that formal registration, that if someone else comes along and pretends to be you, pretends to use your business name and makes some kind of income or causes some kind of loss, that you have some legal rights, and you can make other claims rather than for trademark infringement. You can make a claim for passing off or misleading and deceptive conduct. So there are claims you can make if you to protect your brand if you haven't got that registration secured, but these claims are much more difficult to make. And if you actually have an ownership right of your trademark, it's a lot easier to enforce your brand ownership. So so I wouldn't rely on these, and if you can get a registration, it's sort of always better to. Just going to head on to the copyright section. I got a couple more sections to cover. We were scheduled originally to go to 1 p.m., but I'll keep going a little bit over. For those that have to drop off, we will distribute a recording of the presentation. So don't feel like you won't be able to access the subsequent information that I'm providing. But if you want to stick around and ask some questions, I'll probably go for another 15 or so minutes. And as always, feel free to drop questions in the chat. I think we have a question from Janet, who's asking, what's the cost of a lawyer to register a trademark? Maybe one of the Sprintlaw team members can put in our standard trademark head start pricing. It's, I think, a little over $1,000 for one trademark in one class. It costs additional fees if you do a word and a logo, and if you register in multiple industries, it can cost a little more. But that's the rough price. And yeah, one of our team members can post the pricing in the chat. And as I mentioned, we're doing discounts this month, so it'll be a little cheaper if you move ahead in April with us. So just moving on to the copyright section. So what is copyright? So copyright's the second sort of main form of intellectual property that people are thinking about in business. Copyright protects creative works To use the legal jargon, it protects creative original works expressed in material form. So there's kind of two elements to make sure something is copyrightable. The first is that it has some element of creativity or originality. And the second, that it's expressed in material form. It has to be recorded somewhere, whether it's on paper or electronic form in a document. If you've got a creative original idea, but you haven't expressed it in material form anywhere, that's not the domain of copyright. That might be the domain of confidential information we'll come to later, but that's not the domain of copyright. Copyright requires there to be an actual material representation of your originality. This is a list of some things that are copyrightable. A lot of things are not super business related. Things like songs, unless your business has a theme song, film scores, screenplays, plays, books, illustrations, and drawings and paintings. So those are the more typical versions of copyright. For our clients who are in the creative industries, we talk a lot about those areas because that's a big part of what they do. But for our clients in the non-creative industries, the areas that more commonly we're discussing are things like computer software, website designs, business plans, strategies, business templates and documents, and those sorts of things. So as long as those things have some element of creativity or originality and they're recorded in material form, there may be copyright in them. I mean, this presentation that I'm showing now, you might argue is creative and original. I might argue that. I'm very biased. And it's recorded in material form, which is this Google Slides presentation. So if somebody were to reproduce this presentation, they may be infringing my copyright. I am the author of this. So, when I authored it, I gained the copyright sort of in that. So that gives you a sense of, in a commercial context, areas beyond the more artistic stuff that may be considered copyright. Now, just to expand on it a little further, copyright isn't a registration system. So unlike trademarks, where we have IP Australia, you go through the 7.5-month process and get that 10-year right. Copyright, there is no copyright Office of Australia. There is no copyright registration service that's sort of government backed. The copyright ownership sits with the author, and they own the copyright the second they create it. So whoever makes it owns it. That's kind of how copyright works. Now, copyright can be transferred or licensed under a contract. So most typically in a business setting, either employment or contractor agreements or these things called IP assignment deeds are the way in which an organization or business makes sure that it owns its copyright. So, in the case of Sprintlaw, we have a team of 50 staff. When they create original copyright, the second they create it, in the context of our business, it's theirs. It's actually not Sprintlaw's, but under their employment contract with us, there's a clause called intellectual property rights, which says, immediately upon creation of any original creative works, made in the course of employment with Sprintlaw, hereby all copyright shall be transferred, whether now or in the future, from the individual to Sprintlaw. So that clause says, so you owned it for a split second, but if it was produced for Sprintlaw, you're agreeing to transfer it over to us. And we need that clause in to make sure that we as Sprintlaw actually own the copyright, because otherwise, under the default position in copyright law, the author owns it. And if there's nothing in writing to say otherwise, with some very limited exceptions, typically it will continue to sit with the author. That's probably the first main point for people to have a think about. If there are employees or contractors or anyone that's produced critical copyright or intellectual property for your organization, you want to make sure they've signed some document, whether it's an employment agreement, a contractor agreement, or these things called IP assignment deeds, which we often do that are specific to IP and can cover the past and the future. You want to make sure they've signed some document that you've kind of kept a record of to say, hey, you made this stuff for me. Maybe it was my website design, my graphic design. Maybe it was my strategy documents. Maybe it was our business template suite that we use for everything that we do. Some original work they've created, you want to make sure there's a document that says this goes from me, the creator, to you, the organization. Licensing is another thing you can do with copyright. you know, owners can say, well, look, I want to keep ownership of it, but I want to allow you to use my copyright for a period of time in exchange for a fee, often called a sort of royalty fee or a license fee. So this might be used in the case where you've created a course or a system, or maybe you're creative and you've created music or a video or even some photography, and you want to allow somebody the right to use it, for a month or an event or whatever it is. They're not going to get ownership rights in it, but you're going to allow them to use it in exchange for a fee. So that would typically be done under a license agreement, and that says we're going to allow you to use this copyright. We're not going to give you any ownership rights in it, but we're going to let you use it for this purpose in this region, in accordance with these requirements, in exchange for XYZ fee. So that's a common way that you can sort of exploit copyright, which is a little bit different. So transferring and licensing is very possible with copyright, and incidentally, you can do those things with trademarks as well, of course. Once you have copyright, so you're the author of an original work, the exclusive rights you get are the right to reproduce that work, the right to publish that work, the right to communicate that work to the public, and a bunch of other rights. So if anyone else tries to reproduce it, publish it, share it publicly, and they don't have your permission, they are infringing your copyright. So if you've come up with a graphic design and someone's taken it, used it in their blog post or posted it all over social media or whatever it is, haven't sought your approval, if you were the author of that thing, it's your copyright and they're potentially infringing it by reproducing it or publishing it. Copyright lasts by default in Australia for 70 years after the death of the author, or from when it was created. So whereas trademarks are a 10-year renewal cycle, copyright actually lasts for a really long time. And the second that you make it, if it ticks the boxes for copyright, it's yours for 70 years, unless, of course, you transfer it to someone else who will maintain it for up to 70 years. But actually, their ownership period comes back to the death of the author, the original author, not the date that it was transferred to them. So that's an interesting sort of point of detail about copyright. So in your organization, what are the types of copyright? I kind of went through some of them earlier, but just to recap: software code, graphic designs, photos and videos, business templates and collateral. Now, I should clarify, if you just have a very basic non-original process document, that may not be original enough to have copyright in it. But if you have branded templates or some collateral or some systematic way that you use documentation in your organization that's not functional, it's original, you kind of came up with it and it hadn't been done before, that would be copyright protectable. Advertising copy, books, manuals, illustrations, internal branding documents. You might have protected your name and your logo with trademarks, but the way that you communicate and promote your brand, and the actual implementation of your brand on your website or an app or in a brochure, all those things may not be trademarkable, but they would be protected by copyright as well. So that gives you a bit of a sense of what we're talking about when we talk about copyright. Now, the thing with copyright ownership, as I mentioned, it's owned by the author unless contractually agreed. And so in your organization, you just want to make sure that you've got these clauses in your employment or contractor agreements that cover intellectual property, and make sure that all of your employees and your contractors are passing over the critical IP back to your business that's important to you. You can use this IP assignment agreement, which is often used with founders of companies who may not be set up under proper employment or contractor agreements, and also just people where you've attended this webinar and you're now thinking, I should have got these people under a contractor agreement. You can sign these IP assignment agreements to cover historical stuff, and so that may be worth using. And then I mentioned earlier the license agreement, if you want to use licensing to exploit your IP. We discussed a bit about ownership and licensing before. One other area that may come up in relation to copyright in your business is, you might be collaborating with a client or working with a client on something that involves the creation of intellectual property. Often, for example, for web design businesses, you may provide services where you design a website for a client. And the question is, when their website's developed, who actually owns it? Can you go and use a similar design or source code with other clients? Or is it theirs now? So typically in your service agreement or client agreement, you'll have a clause about what happens if we create some copyright together, who actually owns it. And there's these concepts often of existing IP and developed IP. So, if you're the web designer, you're using stuff that you created before you even knew this client, templates, source code, basic page layouts. Typically that would sit with the web designer. But if you develop something new in collaboration with the client, depends on the arrangement, but sometimes that would be called developed IP, and the contract would say any new stuff we make together is owned by the client, but any existing stuff stays with the web designer. And again, you can apply that analogy to many different other sorts of scenarios. Just noticed a question from Michael, copyright for songs. Assume that's a question about how does that sort of work. In a commercial context, I would say that the song stuff doesn't come up all that much, except for our creative clients. But so I won't go into it in too much detail because it's a whole rabbit hole of copyright law. But if you create a song, there's a few different types of copyright that can exist in a song. One is, the song will be a piece of music with a certain chord progression potentially, or lyrics. Each of those things are different forms of copyright. The lyrics would be a literary work, so there's copyright in just the lyrics. Whoever writes them may have ownership in them. The chord progression may be its own form of copyright for the song, which could protect all versions of the song. Different cover versions, if they use the same chord progression, may potentially infringe the sort of musical work. And then there's a third form of copyright if that song is recorded with a producer who adds effects and a performance and mixes it and masters it and all those sorts of things. There's a third form of copyright in the recording itself. So songs can get quite complex, but again, like everything else in copyright, whoever comes up with it owns it, and then the rest of what happens afterwards is dealt with in terms of IP agreements and IP contracts. One other thing I want to mention about copyright I have on this slide is, in your organization, you may be using forms of copyright. So, you may be using third-party software, you may be using other people's documentation, you may be reproducing other people's copyright in blog posts that you produce. What do you need to do to make sure that you can actually use it? Well, as I've said earlier, if you're using someone's copyright and you don't have the author or owner's consent, you may be infringing their copyright, and they could send you, as we'll come to in a moment, cease and desist, or potentially sue you for damages. So you want to make sure you've got permission, and that can be in the form of a license agreement, or a simple written permission that may form an implied license, but some form of permission that allows you to actually use it and makes you confident that you won't potentially be sort of liable for copyright infringement. One other point of detail for those that work in technology, if you are developing software, original software code, original source code, typically that is protected by copyright. It's the main way that you protect your source code. The authors own it. If they're developers, the developers own it, but then they have a employment or contract agreement, and then ultimately the organization ends up owning the source code. One thing we sometimes see with technology companies is that developers will use open source code libraries, and they'll mix original code with open source code. It's very important to check the terms of your open source code licenses, because sometimes those licenses can say things like, hey, we're happy to let you use our open source code, but if you mix it with original code, you must make all that original code open source. And we've had a few instances where tech clients have, and it's relatively rare because most open source licenses aren't like that. We've had a few instances with clients where they've built an entire application, used a bit of open source code, and the questions arose as to whether they actually own their own source code, or whether it's all been open sourced under the terms of the license that they signed up to. So just a little point of detail for software clients. We got another question. If you have an original logo, that would be your copyright. Why would you need to have a costly trademark as well? So look, if you have an original logo, so you've got a graphic design for your logo, and it meets the requirements for copyright, it's an original artistic work recorded in material form, you could potentially rely on copyright protection for that logo design. it's weaker than a trademark for a number of reasons. First of all, if you were going to enforce it, you've got to prove that it's original. So you've got to go through all the steps of proving it's creative, it's original, and then show obviously chain of custody from the creator all the way to you. Second of all, it's only going to really protect the exact version of that logo and not things that are deceptively similar to it, unless you can show that they literally copied and pasted your logo into Photoshop and added 2 bells and whistles, and you can say, well, they actually took my logo, but you'd have to provide evidence of them actually copying it and editing it. So it's a much more narrow protection. And even, in fact, if it is an identical replica, it can be difficult to show, as one of the elements of copyright infringement is to show actual use or actual awareness of your copyright. So yes, you can do it. It's just a lot weaker than the trademark. And given how important these logo things can be to brands, it's more common to just tack it onto your trademark registration and get that very clear monopoly over the right. Greg's asked as well, can you copyright a process? Yeah, I touched on that earlier, but it's an interesting one. If the process is functional and there's not this creative or original element to the process, typically it wouldn't be considered copyrightable. And there's a bunch of cases which basically say, basic business processes are not original enough to be copyrightable. If you come up with a system or an original process or a way of doing things in a particular application that's quite original or hasn't been done before, that can be, if you can show that it's original, hasn't really been done before, there's an element of creativity to it, and it's yours, then yes, those kinds of processes could be copyrightable. Whether it's a yes or no just depends on the situation. I mentioned patents earlier, but highly inventive processes that involve complex, groundbreaking technology and stuff can sometimes qualify for a patent, which is a really high form of inventorial protection. But again, not really covering them in this presentation because they're often cost over $100,000 to register, so they're really often for larger businesses or people that specialize in them. One other question we have is, do we need an IP agreement transfer when you hire a design agency, graphic designer, to make a logo brand? Absolutely, you need to make sure that there is some IP agreement with external design or graphic agencies. They'll typically give you terms and conditions which cover IP ownership. Those terms and conditions may have been written by Sprintlaw if they're one of our clients, but you need to check them carefully because they may say, we own all designs we create and we just give you a right to use it, and so you don't actually own the IP in your logo or whatever other design work they've done for you. It's not super common, but we have seen instances of design agencies and clients having a genuine misunderstanding as to who owned what, and the design agency basically legally still had the rights to the designs because the contract was unclear. So definitely worth making sure that you check those agreements and edit them so that they include clear IP clauses, ideally to make sure you own whatever they're making for you. Caroline's asked to say a bit more about confidential info. We're nearly at the end, and I've got a slide on that in a moment, so I'll just try and fast forward and get over to that slide. One more slide on copyright. So how do you use / enforce your copyright? One way is to make it clear that it's your copyright. So we've got this, like we have the R circle, we have the C circle. The C circle is not regulated, so you can use it on things that you've created to say, this is my copyright. For example, on Sprintlaw's website, we have a little thing at the bottom that says, got that C symbol, copyright Sprintlaw 2023. And that shows that we didn't register to do that. We can just do that. That shows that it's ours. And if someone tries to use it, we can show that they've derived their website, which might look like ours, from our copyright protected website, which was our original work that we kind of created. So one is just putting people on notice that it's yours, and that can help deter use. The second is, again, similar to the trademarks. If someone is using your copyright, the first step is typically to send one of these letters: cease and desist using my copyright. If you don't, I'm going to take XYZ action. And if they've profited off your copyright or if they have caused you losses, you could potentially also request monetary compensation of some amount depending on the circumstances and what you would like. Again, this is in the realm of private settlements, so there's not specific laws on what the letter has to say or how much money you can and can't request, but typically it will be done with reference to what you would get if you took them to court, which I'll come to in a moment. Now, one area specific to copyright, and I guess it could happen with trademarks too, but we see it more in a copyright context, is people reproducing people's works on social media. People using videos, cutting them up and reproducing them on YouTube, Facebook, Instagram, without permission. So it's very, very common, and really, from a lawyer's perspective, copyright infringement is happening all the time, all over social media, because people are just using people's original works without asking permission and sharing them. And the original authors often don't bother going to the trouble of suing people or sending letters because it's A, not worth it, B, they don't know about it, and C, they might actually like the exposure, and so they don't mind the copyright infringement. So if you're wondering, like, he's saying all this stuff about infringement, isn't that happening every day? The answer is yes, it is happening every day, and just practically people don't bother enforcing their legal rights, but they could if they wanted to. If you're concerned that your copyright's being used on social media, or if you're planning on using someone else's copyright on your social media or otherwise on your website, the legal position is permission is required. If you don't want it to be shared and you can show that it's yours, most of the social platforms have a functionality to report copyright infringement, and typically they take it down pretty quickly. They're potentially liable themselves for distributing it, but certainly the individual that uploaded it is also liable. So there is legal liability going on, which is why they typically take it down pretty quick if there's a notification. And similarly for you, if you're going to build out stuff using third-party works, lawyers like me will tell you get permission before you do it, or use just open source or royalty-free stuff, which by default allows you to use it everywhere without permission. If you want to use someone's stuff without their permission, just do so at your own risk, and know that you could be infringing copyright, and issues could arise from it. Finally, if a copyright infringement matter ends up in court, the remedies are similar to the trademark stuff. You can get damages. Their use of my copyright caused me this loss. Account of profits, they made this money off my copyright, or some kind of prevention or injunction measure which forces them to take it down off the platforms or wherever they're promoting it. So hopefully that gives people a good sense of how copyright works. Now on to the final slide, which I'll just run through quickly, and thank you all for your patience with this, but confidential information. So this is the 0.5 form of intellectual property that I mentioned I would cover. I say 0.5 because confidential information is more in the realm of information rather than property from a legal perspective, but it is a related way of protecting important business ideas and secrets and these sorts of things. So, I mentioned earlier, copyright only protects creative original works recorded in material form. There's this very strong material form requirement. What if you've got a great idea, a great business opportunity? What if you've got a pitch deck, which, you wouldn't care if someone copied the deck itself, but you would care if somebody took the ideas in the deck and actually made a business out of it? What if there's information about a big deal or your future roadmap? All of these sorts of things might not fall under trademarks or copyright, but might be really, really important for your business. So this is where confidential information comes in. This is information you want to keep confidential because you want to make sure that no one else has access to it and no one else uses that to potentially monetize it. So first is identifying what kind of information is confidential info, and that's something to just be thinking about in your business. If you're going into meetings and sharing sensitive information about your business strategies or other sorts of things, that may be confidential. Now, you can't claim something that is available publicly as confidential information. By definition, that will be public knowledge, so not very confidential, but provided that it is genuinely not public information and something that's only known to you or a select few, it may be in this realm of confidential information. Typically, the way you protect this is just through contracts. So the NDA is a classic document that will protect confidential information, non-disclosure agreement. It basically means whoever signs it agrees that any information that they've been provided in relation to whatever the topic of the NDA is, they cannot use it, they cannot monetize it, they cannot tell anyone else without your permission for a period of time, usually. And sometimes it can be indefinite. For your employees and your staff, rather than getting them to all sign NDAs, you typically have a clause in your employment agreements called confidential information, which says the same thing. Any information that you come into contact with during your employment is that's confidential to the business. You must keep confidential. You cannot reuse it, for other purposes during or after your employment with us. And again, that protects you from employees stealing ideas that they learned about in your organization and running off and doing something with it. Pitch decks, of course, for startup companies, often you'll have a pitch deck with some confidential strategy stuff in it. Typically, you can have a disclaimer that says, by receiving this pitch deck and reading the information in it, you agree to keep it confidential. The main thing you want to do with confidential information, whether it's by contract or even just using a confidential header on letters, on emails and things you send, is making it very clear that the information you're about to provide is confidential. Just by doing that, even without a contract, you can start to gain some legal protection, because if someone receives information that they know to be confidential because you told them it was, and they share it or use it in some way that the discloser who told them it didn't approve of or wouldn't be comfortable with, there can be legal claims for confidential breach of confidence, it's called, even without a contract. But the contracts are much stronger, because suing someone for a breach of an NDA when they've signed a document promising not to do something very specific is a very strong way of protecting confidential info. So in practice, if you're in business meetings with potential suppliers, potential software developers, third parties, or really anyone, investors who you're going to share some information that's sensitive with, that you don't want widely circulated, this is where the NDA comes in. They sign it. That means if they try and use that information to do something, it's a breach of NDA and you'll have a legal claim. So then we get over to the third column. What can you actually do? Well, a couple of ways to enforce it. One is breach of contract. Hey, you breached this NDA, you caused me XYZ loss, or you made XYZ profits. I'm entitled to them. Or you can get an injunction, which is the second bullet. So you may be able to sue them to prevent, get an injunction to prevent them disclosing that information. So if you know they're about to disclose it or use it, you can get a quick court order to stop them using that as well. Definitely something we end up doing for a lot of our clients is giving them a template NDA that they can use for sensitive business meetings. And I think we may even have a bot that creates one in our Sprintlaw membership. So for those of you that are members, you can log in and generate a template. Or if there's something a bit more specific you want, our team can certainly help out with the NDA. So hopefully that was helpful in terms of confidential information. That was pretty much all I wanted to cover. Just to recap on the offers specific to trademarks this month, we're doing a 10% discount. If you're a Sprintlaw member, it's 20% because you get 10% anyway. So it's an extra 10% for members on these services, registering a trademark, or just advice around trademarks or renewals or international trademarking. Reach out to our team if you are interested in any of these. If anyone has any final questions, feel free to drop them in the chat in the next minute or two. Maybe I'll leave 20 seconds for people to let me know if they have any questions. Otherwise, we might wrap up. Greg's got a question. How do you protect a process? So again, on the information I provided a bit earlier, I think it depends on whether the process is original or not. Yeah, or a method. Yeah, it depends on whether the process or method is original or not. If it is not original, it's not going to have any copyright protection. So the best way you can protect the process is through confidential information, confidentiality. Anyone that you tell about the process, you make them sign an NDA, or if they're an employee, you just put it in your agreement. Any processes that you learn about, in the course of your employment that are related to our business, or any processes we share with you, are confidential and you cannot use them or share them with third parties. So that will be a way to protect them if it's not original. If it is an original process or a method, it may have copyright protection if you can show that it's original and recorded in material form. So there's some document or strategy around the process. So then it would just automatically be protected, and you just want to keep a record of who created this process, what document did they sign, making sure that your organization actually owns it, and what is this process, and that's how you can protect it. I mentioned earlier, if there is some highly inventive process that you've come up with in manufacturing or technology or pharmaceuticals or something, there is sometimes a possibility of a method or process being patentable, but this really needs to be very, very inventive. It needs to sort of not be published anywhere in any academic journal, and be pushing forward sort of human knowledge, and it can cost really quite a bit of money to get a patent for it. So if it's not in that realm, it's more common to protect through either these NDAs or through just copyright protection and documentation. So hopefully that answers that question. And thank you all so much for attending. This has been fun. Apologies again for the late start and the technical issues, but we'll be circulating the recording if people want to revisit anything. And we'll be doing these, I think, fairly often in the future, these webinars. So if anyone has any feedback on the content or things they want to see us cover, very happy to hear that, and we may do some future presentations on them. Otherwise, thank you all so much for coming, and I'll let you all go. I'll see you later.